Um, Welcome everybody, and I hope you've had a good evening. Notwithstanding our blustery conditions outside, I'm glad you all can be with us from the comfort of your own home, so to speak. For those of you who have been with us the last two sessions, you know what this is all about. But for those of you who haven't, let me sort of recap what we've done in the first couple of sessions. In session one, we talked about the purpose and goals of the series, that being to educate about racism and how legal aid can help dismantle systems that perpetuate poverty and racism nationally and here in Washington state. We also talked about our focus on taking action and our intent to weave into each session ideas for what change looks like, what anti-racism looks like, and what reparations might look like. In our second session, um, we had we heard from Jeff Robinson. Uh, a lot of you know Jeff. Jeff is the Deputy Legal Director and Director of the ACLU Trone Center for Justice and Equality. Jeff presented a powerful and urgent picture of racism and injustice in the United States and how those two factors perpetuate and reinforce inequality, oppression, mass incarceration, particularly as it relates to the Black community. If you couldn't join us for that session, please contact us and we will provide you with a link so that you can review the recording. Um, the recording is not public, but we've been given permission to provide it to our group here. And so if you haven't seen it, I encourage you to see it. It's moving, it's shocking, it's necessary to see and understand. So in a little bit, I will introduce you to Professor David Domke. But before I do that, I get the pleasure to bring good news to this group. I want to introduce you to Murph Eman, Executive Director of Columbia Legal Services, who will share wonderful news about CLS's recent success in the Martinez case. If you haven't heard about the Martinez case, boy, are you going to enjoy this. As all of you know, CLS is the endowment's largest grantee, and Murph has been one of our partners forever and throughout this presentation of this series. Murph has been a tireless advocate for civil legal justice in Washington state for a number of years and continues to guide CLS in preserving and enforcing the rights of those Washington state residents who need help the most. And really, that is what we are about. So Murph, please give us a little rundown on the Martinez case.
Thanks, Ron. So this is a very exciting case. It is a class action lawsuit on behalf of several hundred dairy farmers in Eastern Washington, dairy workers on a dairy farm in Eastern Washington who challenged their wages. And we have at CLS done many wage claim class action cases to enforce the rights of farm workers and agricultural workers. At the same time, our attorneys and advocates were talking to the dairy workers. We were undergoing a change at CLS to focus on race equity. And so they thought about the law and thought about why is it that agricultural workers are exempt from the overtime statute, because the overtime statute is all about protecting health and safety. And they knew that particularly dairy workers, but agricultural workers, that agricultural work is one of the most dangerous industries for workers in Washington state, one of the most. So they started doing research, and what they found out is that the exceptions from the Fair Labor Standards Act happened in the New Deal in the 1930s, and it was a race-based classification. That agricultural workers were left out because Southern Democrats wouldn't vote for it if domestic workers and sharecroppers were included in these protections because they were almost exclusively Black. Well, that law was adopted in Washington almost word for word with that same exclusion. And in Washington, the racial dynamics are different. In our state, almost 99% of farm workers are Latinx. And so they thought about that and thought, can we bring a claim saying that there is a fundamental right to worker safety, the statutory protections of worker safety in Washington, and so excluding farm workers is unconstitutional? Or could they bring a privileges or immunities case and say that it is discriminatory and a violation of equal protection? So they decided to bring all the wage claims, as they usually do, and add these two additional claims under Article 3 of the Constitution, the Privileges or Immunities Clause. So they settled the wage claims after filing a class action lawsuit, which the endowment and LFW funds us to do. Otherwise, all of those farm workers would not have been able to be part of a class action lawsuit. The two named plaintiffs who stepped up, Mr. Martinez and Patricia, were terrified. Mr. Martinez was a little more bold, but Patricia was very, very scared to stand up for her rights. But she decided, with the urging of her mom and the support of her family, to go forward and be one of the named plaintiffs in the suit, which was not easy. So this was almost 4 years ago, and a conversation with them of whether or not they would be willing to do this. So we were eventually able to settle the claims, but the constitutional claims continued after the other claims were settled, went all the way to the state Supreme Court. And last year, Lori Isley, one of our longtime farm worker advocates, argued in the state Supreme Court, arguing that this was a discriminatory exclusion and unconstitutional. And this law had been around for decades and decades and decades and had not been challenged in this way before. And the oral argument, if you get a chance to watch that, Lori gave what some call a master class. We partnered with Mark Coate, a pro bono attorney, who was just a fantastic support. And some of the questions that were asked, for example, growers tried to argue that that it was seasonal work and it was just like any other seasonal work and should be excluded. And Justice Gonzalez asked, and what is the season for milking cows? Which was a lighthearted moment for everyone. And then Justice Mattson said, well, aren't there seasonal workers at department stores at Christmas time, and they get paid overtime? So how is this any different? And so we waited a year. So almost a little over a year from the day the case was argued. It came out about 2 weeks ago in a 5-4 opinion finding in favor of the workers. The clients were ecstatic because not had they just won their case, they had won a case for dairy workers across the state and for agricultural workers, that there is now a fundamental right to worker safety, the statutory worker safety in our state for farm workers, and that has never happened before. And it's a huge day. It means so much for folks to be able to get overtime because it's a safety protection. So we're thrilled. The folks who are working on the case really needed some good news because it had not been good news for farm workers in Eastern Washington this year. There had been people dying, people getting sick. It had been one of the worst most hardest hit areas in the country with COVID. And so this is just a wonderful outcome. And I want to thank everyone for supporting CLS and supporting this amazing work. You can learn more about it on our website. You can read the opinion. Justice Gonzalez's concurrence is worth a shot. And I just want to give a shout out to Ken Masters, who wrote a phenomenal amicus brief on the history of sharecropping and how it relates to this case. And that is definitely worth a read as well. So thanks a lot.
Thank you, Murph. Please, everybody, give Murph and CLS a rousing hand, because what she did was correct something that, as a labor and employment attorney, I find unconscionable. It's simply unconscionable that we can designate a group of people to be less deserving of protection, less deserving of fair treatment, simply because of their race and ethnicity. And I mean, this country, but we've done this in the past, but in this situation, it was truly horrible. And your work and the work of CLS to get this result is simply fantastic. And it, you know, in 2020, dear goodness, we'll take everything that we can possibly get. Everything that we can possibly get. So thank you again. Now, I'd like to introduce you to our main speaker this evening. A lot of you know David Domke. He's a well-known, I'm going to give you celebrity status, David, in Washington for all of the work he's done. Professor Domke worked as a journalist in the 1980s and early 90s. He is currently a professor and department chair in the Department of Communications at the University of Washington. David's academic research has focused on communication, politics, and public opinion in the United States, and he's received the University of Washington's Distinguished Teaching Award, the highest honor for teaching. And in 2006, was named the Washington State Professor of the Year by the Council for Advancement and Support of Education and the Carnegie Foundation for the Advancement of Teaching. But David is a multitasking person, and he is also committed to interracial and intergenerational community building. He's one of a group of community members who created civil rights pilgrimages to the Deep South in 2014. And in 2018, David and an incredible team of colleagues launched the organization Common Purpose, now known as Common Power. The organization's mission is to mobilize volunteers for voters around the country while investing in the next generation of leaders and building lasting community. Common Power believes the most common power we should all have is the power of our vote. His work and the work of Common Power is focused on prioritizing and amplifying the next generation of leaders. This is the true gift of what David and his organization is doing. He is building sustainability for the efforts that they've targeted for real leadership in the area of voting and voting rights. His success is pretty extraordinary. For example, since its inception, Common Power has assisted in voter outreach and mobilization using a team approach in 35 states and currently has active engagement in 25 states. Since April of 2020, the organization has called, sent postcards, and texted nearly 2.5 million people. Since 2018, they have recruited and engaged over 700 active volunteers and more than 2,000 Seattle volunteers as part of their action community. David now serves as Common Power Director of Fieldwork and Learning, and tonight he's going to talk to us about the vote, its importance to our democratic processes, and the historical and continued injustices and impediments that truly threaten the promise of free and fair elections. David, thank you for joining us. Take it away.
Ron, thank you so much for that. That's really generous. Thank you. And thank you to all of you for the work that you do. Listening to Murph's description of the Martinez case, I know colleagues who have worked and do work at Columbia Legal Services. I know how vital this work is. It's really hard. It's really hard work. And so thank you all for the work you do and the work that you have done and that you continue to do. I'm honored to be here tonight to do a little talk around voting in America, which we've just finished an election that it really is a threshold election for the importance of focusing on the act of voting. We've had a presidential and a national election where the act of voting has been front and center. We really haven't had that experience since the 1960s in this country. So it's really valuable in all kinds of ways. And the whole thing is not done yet, as we know. So what I'd love to do here is to go through a little bit of a PowerPoint presentation that summarizes some of the work that, some of the realities that drive the work of Common Power, talk a little bit about Common Power along the way. And then I know there's going to be some Q&A. So if you want to talk about the election, if you want to talk about Georgia, if you want to talk about what just happened in the last 3 hours in the state of Michigan, I'm down for all of this. Okay. In fact, let's just make it a night and just stick around for a while because there's a lot of things that we can talk about here. So really honored to be here. Going to pop up my screen here. Let's see. Oops, I'm not, hold on one second here. Let's see. Yeah. Okay, here we go. I had not hit the right little box, so I couldn't see anybody. Can anybody out there, can you see this? Just give me a thumbs up if you can see the screen. Okay, awesome, great. Voting Rights in America, the 2020 election and beyond. Thanks so much for coming tonight. Here's where I want to start. I want to start with a truth about America and voting that is a painful truth, but one that you all probably know quite well. And is part of the body of teaching and research that I've been immersed in for the last 20 years since I went to grad school and had the privilege to get a job at UW. And I want to start with an excerpt from an essay written by Gregory Downs, a well-known historian, renowned historian who's written about the post-Civil War Reconstruction era. And Downs wrote an essay in 2018 for popular consumption that sought to explain the parallels between Reconstruction and really the last 40 years in America around voting. And I want to quote a portion of Downs's essay. In May of 1862, an enslaved wheelman, somebody who would drive boat, would kind of run the wheel on boats in South Carolina, named Robert Smalls, gathered his family and other slaves on board a steamer called the Planter. While the captain and the white crew slept on shore, Smalls raised the Confederate stars and bars and sailed past the unsuspecting guard at Fort Sumter. 10 miles off the coast, Smalls turned the Planter over to a U.S. clipper ship. Soon he became a celebrity, and thanks to the prize the U.S. government paid him, he became modestly wealthy. Smalls used his fame to organize freed people to protest segregation and to demand their rights. So Smalls gets involved in the civic arena. Smalls' move into politics was part of a vast transformation of American politics. Prior to the Civil War, African-American men could only vote in 6 northern states. But the flood of 200,000 Black men into the U.S. Army and the Navy inspired them and others to claim the vote as their due. Although it took 2 years, congressional Republicans in the Military Reconstruction Acts of 1867 enfranchised African-American men in ex-Confederate states. They put those states under military supervision, and they dispatched generals to enroll Black male voters and call elections for delegates to create new state constitutions. In 1867, during what historian Julie Saville called Registration Summer, which has these echoes that you can hear all the way to Mississippi in '64, hundreds of veterans and activists traveled all through their regions holding meetings. Although freed women could not vote, they lobbied, cajoled, argued, brandished weapons, and even held sex strikes to convince kin and neighbors to register. Registration was their newly acquired badge of citizenship, one government agent said. By the fall of 1867, more than 80% of eligible African-American men had registered. During the subsequent elections, at least 75% of Black men turned out to vote in 5 southern states. Democracy has a long history, but almost nothing to match this story, Downs says. All right, last portion of his essay. Robert Smalls went back to South Carolina and won a seat in South Carolina's 1868 Constitutional Convention and then in the new state legislature. In conventions and subsequent state legislatures, Smalls and compatriots tore down racial barriers. They established public school systems, hospitals, orphanages, and asylums. They revised tenancy laws, and they tried to promote railroad construction to modernize the economy. Reconstruction governments also provided crucial votes to ratify the 14th Amendment, which is still the foundation of birthright citizenship, school desegregation, protection against state limits on speech or assembly, and the right to gay or same-sex marriage. But like every revolution, this one inspired a counter-revolution. And that last sentence captures the story of American voting justice since the Civil War. A step forward is met by a massive response. It's another step forward and progress of some people, usually peoples of color, and then women, and then generally Native Americans, and then another reconstruction that occurs in the civil rights movement is met by a massive response by overwhelmingly white and wealthier people who are concerned about the America that is changing before their eyes. We live in the middle of one of those counter-revolution moments that has been going on really for about 4 decades, but particularly in the last 2 decades, which is where I'm going to focus most of my lecture on tonight. But that is the reality. Revolution meets counter-revolution. Okay. Voting in America generally. Now, there's no way I could even possibly begin to do justice to the incredibly nuanced and heroic body of work around voting rights and voting justice in America. But I do want to hit a couple of the high points of the story, or they're actually low points in several instances of the story. Okay, and I'm going to take as my anchor piece, or my anchor element, the Voting Rights Act of 1965, considered by constitutional scholars as one of the most important pieces of small d democratic legislation ever passed by the US Congress. All right. The Voting Rights Act was necessary for several reasons. We start with the reality that at the founding, voting laws were left to the states to decide upon things. This is because who the white power brokers in each of these states wanted to vote varied from state to state. And so the founders punted on this and left it largely to the states. There's very little in the US Constitution originally as written that deals with voting at all. So states had the ability to set their own laws, and they continue to exercise enormous power over voting in this country. For most states at the beginning, voters were defined as white people who were mostly men. And I see I left a word out there, and mostly property owning folks as well. So mostly white and males and mostly property owning folks were who got to vote in the beginning of this country. In the United States, women got the right to vote for a couple of years in a few states, and African-American men had the right to vote off and on for periods of time. And eventually there's 6 states that allowed them to vote as of the Civil War, but it was mostly white men in America at the beginning because states got to decide upon this. It was not immigrants either, because most states didn't want to allow immigrants, even though everybody was a recent immigrant to this country. All the citizens in this country were recent immigrants, but they still didn't want new immigrants coming in to vote. The civil rights movement really was the first kind of significant challenge to white supremacy that began to actually change voting laws. There had been enormous day-to-day challenges to white supremacy by activists, by heroes, by foot soldiers throughout American history. But we really begin to get the changing of policies during the civil rights movement. And there are 4 key civil rights acts that occur in the 1955 arena to the 1965, which is kind of usually the kind of bracketing around the civil rights movement is usually by historians kind of given from either 1954 with Brown versus Board of Education or 1955 with Emmett Till through 1968 in Dr. King's assassination. 1957, 1960, and 1964 were the first 3 civil rights acts to pass Congress after Reconstruction. And 57 and 60 did not go near far enough. They were really watered down, but they were steps in the right direction. In 64, the Civil Rights Act is a monumentally important civil rights law dealing with public accommodations, as you all probably know very well. But it did not, in its final passage, deal with voting at all. When it was first put forward by John Kennedy before he was killed, it did have a significant voting section in it. But by the time it got through the Southern Democratic filibuster under Lyndon Johnson, voting had been completely stripped away from the 64 Act. So with this reality and with the importance of the vote, civil rights leadership knew that they needed to really do something dramatic, or they were going to lose the moment of momentum that they had around voting, civil rights and voting rights generally. So they scheduled and put forward a voting rights campaign in Selma, Alabama. Selma was kind of the updated version of Birmingham from 1963. Birmingham had Bull Connor. Selma had its own horrible white racist sheriff, Jim West. And they decided the civil rights movement decided to focus on Selma. And so it's this really small town in Alabama. Maybe you've been there. It is a transcendent experience to go there and stand on the Edmund Pettus Bridge. And they focused on Selma and they marched across that Edmund Pettus Bridge on March 7th, 1965. 600 local Alabamians, almost all of them Black Americans, came across that bridge. And the bridge, that is the Edmund Pettus Bridge there. And that bridge has an arc in the middle of it. And you cannot see over the top of the bridge until you get to the top of the bridge. And when those Alabamians came over that bridge with John Lewis in the gray trench coat on the right and Hosea Williams on the left, and they looked over and they saw a sea of Alabama state troopers. And those state troopers were lined up across the road. And where they were trying to march was from Selma to Montgomery, Alabama, to petition George Wallace, the governor, for voting rights. And Wallace had unleashed the state police to stand there to block them. Behind the front lines of the police were more deputized white men on horses, all with batons and clubs. That led to a mass beating in which these folks were beaten a full mile back to Brown Chapel, where they had started from. And they were then surrounded essentially by the police for days on end. Eventually, they would come back and would march with the protection of federal troops because of Lyndon Johnson. They would march 2 weeks later, and they would take 5 days to march to Montgomery. But this dramatization, which that is the word that John Lewis consistently used throughout his work in the civil rights movement, is that he would always say we need to dramatize the situation. He said we wanted to make manifest the inequalities, the racism. This dramatization caught the national attention and led to the creation of the Voting Rights Act of 1965, which was passed a few months later. I'm going to stop for a second and just say this reality, this history is so meaningful to me, is so transformative in my professional and adult life that this has led me to make a decision that action is more than just teaching for me, that it needs action out in the civic community. And so I'm on leave from the UW right now to do this work at Common Power. And that image right there is so important to me that I have it right here. I have it right here next to my desk. It's from the cover of Life magazine, that photo right here. And it is a touchstone to me in the courage that we need to display on a daily basis, the courage that these people put forward just for the right to vote in America. Certainly echoes to me across time of what's the least I can do to help. Well, the least I can do, really, it's not much, but it's what I can do is to do this work in Common Power. The Voting Rights Act gets passed after Lyndon Johnson addresses the nation. In that March 15th address, Lyndon Johnson famously says that it's all of us who must overcome the crippling legacy of bigotry and injustice. And then he has a long pause, and then he says, and we shall overcome. And that was the anthem of the civil rights movement. And some of you were there. Some of you sang that song all the time. It was the president saying to the movement that you have captured my heart and my commitment. As flawed as Johnson was, and this is a very flawed man, he got a lot of things right around civil rights and voting rights. That phrase, "and we shall overcome," would be the equivalent today. And I think we will hear it from our president-elect when he becomes president, of saying Black Lives Matter. All right. "And we shall overcome today" is the anthem that echoes to us today, to the work that we do for justice. Well, the Voting Rights Act of 1965 is so comprehensive, so many sections to it, that it set out to essentially play whack-a-mole with all of the ways that have been used to deny voting rights to Black Americans in the South and to Asian Americans on the West Coast. It's set out to essentially get rid of all of these. And so it has section after section dealing with all of these clauses that say you can't do this, you can't do this, you can't do this, you can't do this. And it was monumentally impactful. And so I want to compare 6 Southern states from 1965 to 2004. And I want to show the percent of people who are registered to vote who are white or Black in these states in 1965, and then 40 years later, what percent were registered to vote in these same states, again, among African Americans and white Americans. In 1965, with the blue lines being white voters and the orange line being Black voters, this is the percent of the populations in these states who were registered to vote. They all had the right to vote, but these are the folks who had been able to actually get registered to vote, who had been able to overcome the literacy clauses, the understanding clauses, the poll taxes, the outright violence and intimidation, the shenanigans of closing voting registrar offices on most days of the month, except to whites who could come in a side door. And the argument that whites in the South would make is that the reason we have these discrepancies in these Southern states and these white voters are so much more registered than Black voters, the argument was made that it's because Black voters didn't want to register to vote. They didn't care. They didn't want to. They were happy. This is a bunch of crap. We know that. And to dramatize how much this was wrong, the Mississippi Freedom Summer of 1964 not only registered voters, they also ran an entire shadow set of elections in Mississippi using the Mississippi Freedom Democratic Party to show how much Black voters would actually vote if given the chance. Happy to talk about all of that, that period of time, but these folks are just, they were so courageous in the work that they did. 40 years later, these same states, this is the distribution of voter registrations in these states among white voters and Black voters. And we can see across these states that there's some modest differences in a state here or state there, but across them, there's really no differences between white voters and Black voters in these states. Now, this is 16 years ago in 2004. And I used the 2004 data for a very particular reason, because it is the data that is used by the U.S. Supreme Court eventually in a 2013 monumental Supreme Court decision in Shelby County versus Holder, or v. Holder. They look at exactly these data, and it leads the court to conclude that we can get rid of a portion of the Voting Rights Act in 2013. It leads them to get rid of that. And in that case, and I apologize if I'm covering ground that all of you know already so well. I know as a teacher, sometimes I go into talks where the people know an awful lot about the stuff that I'm talking about. And it is definitely in the back of my mind right now that I'm talking to a bunch of legal experts, okay? But in the dissent in that court decision, Ruth Bader Ginsburg makes the point that, yeah, America has changed. And that's why we need to keep this law, not get rid of it. We need to keep it. And she uses the analogy of holding a umbrella in the middle of a rainstorm, in which the umbrella is the voting rights law. And she says to get rid of the Voting Rights Act is like getting rid of an umbrella in the middle of a rainstorm and thinking that you're gonna stay dry. It just isn't gonna happen. Once you get rid of the umbrella, were not going to stay dry. And indeed, that is what's happened in America since that decision in 2013. And it's what I want to talk about here for the rest of this kind of talk. So the Voting Rights Act of 1965 has been challenged and questioned legally ever since it got passed. It was challenged immediately after its passage by folks who said it was discriminatory against certain states and not other states. It's the states' rights argument again. And the defenders of the law said, you're right, it is discriminatory because you have created, it is like the theory of discriminatory. It is discriminatory in that respect because you have created racist voting patterns in certain states and not in others. So we're gonna set up laws to deal with that. But it's been challenged forever and ever. And one of the things that Congress has done every time, has done with the law, is they always had a sunset clause involved, which said that the law would expire after a certain amount of time unless the next Congress renewed it. So it was to expire after 5 years, but Congress renewed it in 1970, same in 1975. Then they set it for 7 years and it was renewed in 1982. In 1982, it was renewed for 25 years and it would have expired in 2007, but it was renewed in 2006. And in all of these instances, the vote in Congress to renew it is overwhelmingly favorable to renew it. But that masks the real kind of sensibility among the members of Congress. The reality is that the law would pass all of these years. And there were an awful lot of politicians who opposed the law or the extension of it, who made the political calculations that this law is going to pass. And because of that, I'm just going to vote yes on it. I'm just going to vote yes. There's no upside to me voting no on it. So in 2006, when both the House and the Senate renewed this bill, renewed the Voting Rights Act, it was renewed by a 98-0 vote in the US Senate. And there is just no way that that is the actual distribution of support for the Voting Rights Act. When you look at the actions of the current Congress that we have around voting rights. So it's really more like probably a 70-30 vote distribution in the US Senate, or percentage-wise in the House, for the Voting Rights Act. Every single time it's been renewed, it was also strengthened and applied beyond just its original points of focus. So it began to include ballot languages that needed to be there for ballots or for ballot information. It began to be applied not only to southern districts, but also to some northern districts that also had discriminatory racial histories to them. So it was always strengthened, passed and strengthened each time. Now, in 1982, when the bill was being considered, the Reagan administration had to make the calculus of whether they would sign the bill or not. Every White House always has to sign the bill into law. So in 1982, when they were considering when the Congress was debating it, the Reagan White House was doing its own kind of sensibility around whether they wanted to support the Voting Rights Act. Would they come out in support of it? What was going to be their position? Would they sign it into law? Would they try to veto it? They were doing all their kind of legal thinking about this. And there was a lawyer in the Reagan Department of Justice who was tasked with writing the argument, making the argument for why the Voting Rights Act was a problem and was legally suspect. And you all know that it's not uncommon for folks in legal offices or on cases to have to write arguments that they don't agree with. And that's part of their job because they're trying to either advance a case for a client, or they're just simply trying to figure out what are the best arguments against the argument that they're advancing. But there was this lawyer in the Reagan defense, in the Department of Justice, who was known for being quite hostile to voting rights. And he was known for really, really strongly disagreeing with the Voting Rights Act. So he was chosen by the Department of Justice to write the memo, making the argument for how the Voting Rights Act was flawed. Well, he was so invested in these lines of argument that he wrote 25 memos. He went way beyond the call of duty here to write 25 memos criticizing the Voting Rights Act. And his arguments really kind of boiled down to two things. First, that the Voting Rights Act should be enforced only when discriminatory intention in voting laws could be proved, not simply discriminatory effects. And part of what had made the Voting Rights Act so powerful is that it had based its claims of outlawing discrimination based upon whether a law had an effect of discriminatory, of racial discrimination in it, not whether or not there was intention behind it. We know how difficult it is to prove intention in any set of behaviors, from the way you drive your car to a court decision that might be issued, to a speech, or to a senator from a southern state calling a secretary of state in another state and just having a conversation about, voting and absentee ballots. Just hypothetically, it's tough to figure out what intention could be in such a phone conversation, which allows folks to deny intent. Well, the Voting Rights Act said we don't care about intent, we care about effects. And this lawyer said, you know what, that's too easy of a standard, effects. We should make it intention. We should only apply the Voting Rights Act against discriminatory laws if you can show that the people who made those laws intended for them to be laws. That's a super hard barrier. We know that. That's a super hard threshold, but that was this person's position. The second line of argument of this individual is that voting rights violations should, and I'm quoting now from him, should not be made too easy to prove and would lead to, quote, a quota system in electoral politics if they were made too easy to prove. Well, if we go back to the 1980s, the language around quotas was a deeply racially loaded language in the 1980s. It led to a Supreme Court decision around quotas in higher education. The Reagan administration put forward the racially imbued imagery of quota queens. And so for this person to wade into that space and to talk about quotas was really inflammatory. Well, this person's arguments did not carry the day, and the Reagan administration did sign into law the renewed version of the Voting Rights Act, but it was going to be overridden if they had vetoed it. So the Reagan administration signs it into law. All right. And this would be just an interesting little aside in a broader arc of the kind of arc of voting rights, except this person comes back into the scene. Behind the scenes in the 2000s in Florida, when the Bush team is arguing that there should be a stopping of the recount because Bush's lead was diminishing and diminishing in the state. They argue there should be a stopping of the recount. Ted Cruz, who is not the lawyer I'm talking about, Ted Cruz was on the Bush campaign, and Ted Cruz said, look, if we're going to win in Florida, then we need to bring in the best kind of legal scholar out there. We need to bring in this guy to help us craft our arguments, and then we can have our litigators carry forward those arguments in the court of law. So this person was brought in and made the case for stopping the recounts in Florida, bringing up some of the points made earlier that these things, you have to show intent. You remember the intent of the Chads became a very big deal in 2000 in that case. So this lawyer becomes kind of the behind the scenes star for the Bush team. And in 2003, President Bush returns the favor to this lawyer and appoints this lawyer to the U.S. Circuit Court of Appeals for the Washington, D.C. Circuit. And the U.S. Court of Appeals for the D.C. Circuit is, by many folks considered the most influential court of appeals because it deals with all of these legal governmental sets of policies and decisions to be addressed. So Bush appoints this person to the U.S. Court of Appeals, returns the favor. This is a lifetime appointment for a federal court appointment. And so he's on the Court of Appeals in 2003. And then in 2005, President Bush appoints this person to be the Chief Justice of the United States, John Roberts. This is John Roberts. Okay. This whole narrative arc is to understand where our Chief Justice stands on voting rights, okay? Where he stands on voting rights. And the beauty, and I put that word in quotes, the beauty of the conservative decades-long strategy is that they were advancing this person and giving him opportunities to move up through the system. At the same time, there were a set of state and local lawyers who were preparing the arguments and the cases that would be brought to the Supreme Court the moment that the court began to have the composition that they were looking for. Roberts' ascendancy as the Chief Justice of the Supreme Court in 2005 is that moment that unleashes this revolutionary response to the Voting Rights Act that has taken hold really since Roberts became Chief Justice. Okay. And so I want to use a graph from the Brennan Center at New York, named after former Supreme Court Justice William Brennan. And the Brennan Center is a great resource for voting justice in America. And they track voting rights laws. And I want to show you the map of the continental US. And every state in red has passed more restrictive voting laws since 2010, which is the first election after Barack Obama was elected, and is the, shortly after John Roberts takes power, and about the amount of time that takes a case to get to the Supreme Court with a new Chief Justice. All of these states in red are states that have passed more restrictive voting laws since 2010. It is exactly 25 of our states. It is, mostly states that we would call politically red, but not all of them. You have a Wisconsin, a purple state in there. I guess maybe you'd need to call Arizona a purple state these days. But most of these states are red states, conservative states that have made the argument that there's enough voter fraud out there, which is completely not true. But they've made this argument and have led to the passage of state voting laws, making it harder to vote. All right. I want to spend a little bit of time on this, and I want to share with you a subset of the kinds of laws that have been passed. What are these tougher voting laws that have been passed? The most common, it's now in 35 states, are proof of identification laws. A set of laws passed at the state level that requires voters to show identification proving who they are. Now, there's a really logical argument that this should be in place, that ID laws should be in place, that a voter should have to pull out an identification form to show they are who they are. If we have to have a driver's license to drive a car, or if you need to show some kind of identification in order to get certain kind of medications, it certainly doesn't seem unreasonable to have an identification law in place for someone to vote. So the theory behind it is not, in my view, anti-democratic, small d anti-democratic. And I would be okay with it if everybody in this country got a voter ID card and that we went out of our way to get that card to everybody, okay? But that isn't how it works. We don't have that. We don't have a national voter ID card. And also states get to decide which identification forms count legally. So they get to pick which ID laws count. And that is not done randomly, and it is not done impartially. It is done by state legislatures who have very specific partisan agendas to them. As an example, in the state of Texas, a gun license identification is a legitimate form of voter ID, but a college student ID is not. Gun license owners are older and whiter and vote Republican. College students are younger and more diverse and vote Democratic. In that state, allowing one and not the other is a decision that has discriminatory effects to it, okay? In the state of Missouri, after a set of racial injustice protests in 2015 by predominantly Black students at the University of Missouri, led to the state legislature, predominantly white and rural, to punish college students in the state, and they removed college student IDs as a legitimate voter identification form in the state after that, okay? So the devil is in the details, which IDs count. And this is not done impartially at all. It's done overwhelmingly by Republican legislatures to benefit Republican voters. A second kind of tougher restrictive voting law is a closing of Department of Motor Vehicle offices. DMV offices are where most people in this country register to vote. And closing of DMV offices, particularly across the rural South and Midwest, has led to poorer, many white working class and also many Black working class voters in the South not being able to get to a nearby DMV office. In Seattle, if you close a DMV office, it's not a far drive to another one. But if you're in rural Alabama or in Texas or in the Dakotas, you may have to drive hundreds of miles to get to a DMV. And that is not something that everybody can do. They don't have a car, they don't have time, they don't have the money to pay for the gas, all of this. So the closing of DMV offices, again, is not done randomly. It's done in predominantly parts of the country where there are people of color and lower income voters. These voters tend to vote Democratic. We also have reductions in voting places. We saw this play out time and time again in the primaries and in this election. And we see long, long lines because of this. You cut back polling locations, and all of a sudden, you only have one polling location per county in Ohio, or you have one per county in certain areas of Georgia. And in theory, one per county sounds equitable, but when you're talking about Fulton County in Georgia versus counties in the rural southern part of Georgia, you're talking about a 1 to several 100,000 ratio in the suburban Atlanta or downtown Atlanta relative to 1 to a couple hundred people in some of these rural counties. So reduction in voting places overwhelmingly tends to hurt people in urban spaces who tend to be people of color who tend to vote Democratic. Okay. Another restrictive voting law has been to take people off of voter registration lists, which are called voter rolls. In every state, there's a voter registration list. If you're a registered voter, you're on that list. That's how they know how to mail you a ballot in the state of Washington. But you can be removed from that voter roll. And some states are very aggressive in removing people from voter rolls. This is legally permissible, but you have to do it under certain characteristics. And states have leveraged those and have pushed the envelope to figure out what characteristics they can do this in. We now have states removing voters who are characterized or decided to be infrequent voters. In the state of Ohio, for example, if you don't vote in 3 straight federal elections, then you can be removed from a voter roll because they say you probably have moved. And so we can't even, you're not a regular voter, you've probably moved, so we can remove you and you can re-register to vote because they're legally bound to send you a postcard telling you they're removing you. That's what they're legally bound to do. But we know most Americans throw out that kind of stuff. So if that's the only notice you get, then that's not enough. We are purging people from voter rolls without giving them sufficient notice. And what happens is they go to vote and they're told by the folks there that you are not on the voter registration list. You can cast a provisional ballot over here, but we're going to have to match up your signature. And if we have an ID law in the state, you're going to have to return within a certain amount of days and show us your ID. So the moment you get removed from voter registration lists, it becomes harder to vote in states. This is a reality in a number of states. Lastly, I'll just say that in a lot of southern states, they have absentee ballot laws that allow everybody over the age of 65 to get mailed an absentee ballot every election. And the argument is that we do this because it's harder for 65 and older folks to be physically mobile to come to the polls. Well, it is also the case that 65 and older white voters tend to vote more for the Republican Party. So there are all kinds of Republican incentives to allow these voters to get mailed an absentee ballot every year. In this year, a number of Democratic organizations or progressive organizations tried to remove that age restrictions and to say, can we just mail the absentee ballots to all of the voters in these states? Just because the 65-year-old voters have this special thing, shouldn't we be able to do it to everybody? And doesn't this work against the 26th Amendment to the Constitution, which says that everybody 18 and over should not be discriminated against when it comes to voting? But the reality is that the states refused to do this, and it didn't happen. A number of states, as I'll mention in a second, did make COVID voting changes, but they did not make them on the basis of age changes. And so across the South, we had over 65-year-old voters getting mailed absentee ballots and other folks having to go to polling locations in a Texas, in a Louisiana, in a Mississippi, in Alabama, in Arkansas, in Oklahoma. Okay. All of these 5 things that I've mentioned have all been upheld by the Roberts Supreme Court. All right. The proof of ID laws were upheld in 2008 in a Supreme Court decision that was, I think it was the first major voting rights decision that the Roberts Court decided. It was an Indiana law. It was upheld. They said at that time that until we see evidence that this is discriminatory, we have to first see intention, and we don't see intention discrimination. So we're going to allow these. As I said, it's now in 35 states. These two pieces over on the right were both allowed in the 2013 Shelby decision that wiped out a portion of the Voting Rights Act. The Voting Rights Act previously had required all states that have been shown to be discriminatory and racially discriminatory in their voting had to get pre-clearance to make any changes in their voting laws. But that was wiped out by the 2013 decision. So now states can do these kinds of things, close DMV offices, reduce voting places without any intrusion by the federal government. And this is happening all across red states in this country. The purges of voter rolls were upheld in a 2018 Supreme Court decision. And the COVID age decisions did get to the Supreme Court this election through several states. And the court said there might be a justiciable portion here, but we're not going to decide this in the middle of an election. So bring it back to us after this election, and we'll consider whether the 26th Amendment should allow everybody, regardless of age, to get absentee ballots. But we're not going to decide this in the middle of COVID. So in all these instances, the Supreme Court has upheld these sets of changes. This is what the Roberts Court has done. This is what people who are fighting for voting justice are up against now. And the Brennan Center wrote a report about these laws across the country. And so I quote from the Brennan Center. First, partisanship played a key role in these laws. Of 25 states with new restrictions, 20 were passed by entirely Republican-controlled legislatures. According to a study by the University of Massachusetts at Boston, restrictions have been more likely to pass, quote, as the proportion of Republicans in the legislature increased or when a Republican governor was elected, unquote. That is not a partisan statement. That is a factual reality. Second, race was also a significant factor. Of the 11 states with the highest African-American turnout in 2008, 7 have new restrictions since 2010. Of the 12 states with the largest Hispanic growth, 2000 to 2010, 9 passed laws making it harder to vote. The University of Massachusetts at Boston study shows states with higher minority turnout were more likely to pass restrictive voting laws. And a University of California study suggests that legislative support for voter ID laws was motivated by racial bias. This is not news to anybody who does work around race and equity. What's occurring in this country when in the state of Michigan, Wayne County, my county I grew up in, tries to deny the city of Detroit certification of those ballots, but is allowing all of the white suburbs around it to certify. That was where we were at 3 hours ago. They have since reversed course in allowing all of Wayne County to certify. But it's based in this idea that Black people cannot be trusted around voting fraud. That's the argument. And thus, we need to make it harder for them to vote. Partisanship and race, the alchemy, the intertwining is very powerful in this country. And it's been part of my own wake up as a professional, that one party in this country, deeply imperfect though they are, cares about voting for all. And one party, even more imperfect, is trying to eliminate the right to vote for certain bodies of folks. Okay, I'm wrapping up here now. But the cause is not lost. And we can fight to expand voting laws, and that is the work or part of the work of Common Power. And in 2020, all these states in green are states that we pressured the governor, the senators, and the secretaries of states in those states to expand voting access for this year during COVID. They expanded absentee ballots for this year. They added more weeks of early voting. They wiped out signature requirements. They added stamps on return envelopes. They did a whole bunch of things in these states. So we made a lot of progress for this year. And in some of these states, these are permanent changes. These are changes that will last, that were set in, they weren't just passed for this year, they're going to last. But in a number of states, this progress will be under absolute assault after this election. And it's already clear that in the state of Georgia, that the Republicans there are intending, as soon as the legislature is convened in January, to begin to repeal back some of the laws like automatic voter registration and increased absentee voting in this election and drop boxes that were put into place. They want to get rid of those because of the results in this election. So this is the work that voting justice is about. It is actually about elections and it is about policies. And we at Common Power are committed to both of those. And so I just want to leave you with one possible reality that we have at our fingertips if the Democrats can win 2 Senate seats in Georgia. We could pass the John Lewis Voting Rights Act. And what an incredible thing that would be, to have Georgia be the place where it gets the Democratic Senate to the place where it can pass this, because the House is ready to go. They are already passed H.R. 1 in 2019, which is a voting rights reform bill. Nancy Pelosi has said it will be job one after coronavirus legislation for the new House of Representatives. If we can get a Senate that will affirm this, then we know Joe Biden and Kamala Harris will sign it into law. And what would be in this? Well, here's what our Vice President-elect said back in April when she introduced the Vote Safe Act, which she and others have now transformed into this idea of the John Lewis Voting Rights Act. We would invest money to expand vote by mail and early voting. That would be so awesome. We would invest money to improve the security, both the integrity and the actual health security of polling locations. We need to fix our machines, for example. We would implement no excuse mail-in absentee voting so that everybody can vote from the comfort of their home. Everybody could have the opportunity to do what we have in Washington. And at least 20 days of early voting for every state in this country, because there are many communities that want to vote in person. They don't trust the mails, they don't trust the drop boxes, or they just have a great meaning embedded in going to the polls. As Kamala Harris says, voting is a fundamental right. We must protect it. We now have a vice president-elect that is deeply committed to this. We probably have the biggest opportunity for voting rights progress in this country that we've had since 1965 in America. But this is where Georgia becomes very important for this outcome. So I want to leave you tonight with John Lewis, an American hero. This is John Lewis at Black Lives Matter Plaza in Washington, D.C., in his last, or one of his last public appearances. He had stage 4 pancreatic cancer before he passed away in July. And after the George Floyd protests began and Black Lives Matter Plaza became a place, he went out to Plaza and they cleared the folks around him so that he had space for his health, and he just took it in. This warrior, this American warrior for voting justice. This is the work we can do. This is the moment that we have. We're crossing another kind of bridge. And I want to finish by sharing a speech that John Lewis delivered last year for H.R. 1. And then we'll get to Q&A here.
The gentleman from Georgia is recognized.
Madam Speaker, I rise in strong support on H.R. 1, and I urge each and every one of our colleagues to support this bill. Madam Speaker, you have heard me say on occasion that the right to vote is precious, almost sacred. In a democratic society, it is the most powerful nonviolent instrument or tool that we have. In my heart or hearts, I believe we have a moral responsibility to restore access for all of our citizens who desire to participate in the democratic process. Many people marched, protested for the right to vote. Some gave a little blood, others gave their very lives. This weekend, many of our colleagues traveled with us to Alabama, to Birmingham, to Montgomery, and to Selma. They saw the signs in the museums that said white only, color only. They visited the First Baptist Church in downtown Montgomery, where we feared for our lives as the mob waited outside to attack and kill us. They stood on the Edmund Pettus Bridge, crossing the Alabama River, where we were beaten, trampled, tear gassed while attempting to march from Selma to Montgomery to dramatize the need for voting rights. Madam Speaker, you have heard me tell the story before, and you know our work is not finished. It makes me sad. It makes me feel like crying when people are denied the right to vote. We all know that this is not a Democratic or Republican issue. It is an American one. For the past few days, I listened to the debate on this bill. I spent some time having what I call an executive session with myself. The words of Dr. Martin Luther King Jr. came to mind. He would often say that the arc of the moral universe is so long, but it bends toward justice. The vote is an opportunity to be on the right side of history. It is a chance to cast a vote by the people, of the people, and for the people. So I ask you, if not us, then who? If not now, then when? The time has arrived to tear down the barrier to the ballot box. Today, we are able to do our part in this long fight for the very soul of our nation. Let's save our nation and redeem
time has expired.
The soul of America. Thank you very much.
So that's what I came to say.
Thank you so much, David. Powerful words. It's hard to follow that, knowing what we know today. We have some questions. I'd like to start off by asking you, David, well, what's happening in Georgia right now? What can folks do? What actions can they take? How has your organization been working to bring about a fair election in Georgia?
Sure. So we are laser focused on Georgia, just as a number of civil rights and voting rights organizations around the country are right now. We have the the new John Lewis, Stacey Abrams, there leading the way, and her work with New Georgia Project, which she started after the Shelby decision, and Fair Fight Action, which she then started in 2018 after the outcome of the governor's race there, is leading the way. And so we are, at Common Power, we follow the lead of our partner organizations, and New Georgia Project is our primary partner in the state. And what they're telling us right now is that the very best thing that organizations around the country can do is stay where they are and make phone calls, send texts, and send postcards to them, to voters in the state of Georgia. They said, don't come here. If we want you, we will ask you, but don't come. And they don't want us for all kinds of reasons. Strategically, it's not a good image to have people coming from around the country to save a state. I put that word in quotes. Also, COVID is a disaster. And so to come from around the country is not good. So there's a whole bunch of reasons why the best thing we can do right now is stay here. So we have a Georgia, on our page, commonpower.org, we have a Georgia Senate tab at the top of it. Actually, hang on here. This is one of the great things about Zoom, okay? So here's our web page, commonpower.org. And right at the top is a Georgia Senate tab. And if you click on that, you go to our Georgia Senate action, and it's got a set of kind of principles that are guiding us. But then it gets down to the real stuff here, which is our action calendar. I loved the beginning, Ron, when you talked about the importance of action. Okay. I'm a professor. I've been a professor of communication for 20 years. And I'm here to say that words and language matter tremendously, but at this time of day in our life, actions got to carry the day. They got to carry the day. All right. And so we get down here to the calendar. Here's today right now. And every single day up through the 20th, and we'll be adding more because we're just taking it a couple of days at a time right now. These are phone banks. That's what these are. These are phone banks. All you got to do is go to a phone bank. When you go to a phone bank, you will be met by one of our leaders in Common Power. This is a Common Power phone bank, and we are calling for either Ossoff or Warnock right now. We will be adding text banks as well. Now, if you scroll down a little bit more, there's also right here a postcarding link. And so we have a whole bunch of college age students who run a program for us called Action Academy that are heading up our postcarding. And that's just unfolding right now to send postcards to that state. And we have postcards that get mailed to us. We fill them out and we usually send them back to our partner organization who mails them then from a Georgia postmark on it. So this is the work that we're doing right here. That's one piece of the work. A second piece of work real quick is our Advocacy Tab, which is us pressuring elected officials around the country to engage in election integrity, to count votes, to certify votes, to do it all with integrity. And these highlighted states are the states that we are focusing on. And in every state, we have the contact info for the governor, for the Secretary of State, and for the 2 U.S. senators in those states. And we give that to people, and we've created scripts for you to contact them. So step 1 is here's the scripts. Step 2, here's the contact info. We ask you to call, to tweet, or to email them. And then step 3 is just tell us what you did. You may think like, I live in Washington. Does it really matter if I call the Secretary of State in Georgia and tell him, hey, make sure you do the right thing? Let me assure you that calling the Secretary of State in Georgia today is an act of patriotism. All right. That is a man, a Republican who is standing strong against fellow Republicans for the battle of election integrity. He is literally taking his life in his hands right now. And the least we can do out here is tell him that we appreciate the work that he's doing. But it isn't just him. My new heroes are these secretaries of state, Ron. Okay. They're my new heroes. Jocelyn, I know him by name. Jocelyn Benson. Jocelyn Benson in Michigan today kept her cool when all this went down in Michigan, and everything's good there. Katie Hobbs in Arizona. Another couple folks in Pennsylvania is Catherine Bookvar. These are amazing folks. So we want to call them and pressure them and / thank them for their work. And so this is a really easy thing to do. So that's under advocacy. So those are 2 things that we're doing, Ron, is we're doing that. We may travel there if we're invited down. Like right now, it looks like the most likely to travel for us will be our younger, more diverse members of Common Power. And we need to fund them to go. So if you're at all open to making a contribution to support them going, New Georgia Project has said that's who they would like, first of all, to come, because they want to register in communities of color and younger voters. And we know voter registration is open to the 7th. And then after that, they want to mobilize. So we're doing work remotely here. Hundreds of people are part of this work with us here. And we'll probably send some of our younger, diverse folks there.
David, could you tell us a little bit about the presentations you're going to do on the 23rd and 24th of this month?
Sure. Thanks, Ron, for bringing that up. So I'm going to drop this in the chat. I'm going to do 2 lectures on Georgia next Monday and Tuesday. And it's about how the Biden and Harris campaign won Georgia, and also how the Senate Democrats can go about winning Georgia. It's they cost money. The money goes towards Common Power, towards the work that we do, and they're online Zoom, just like this. They are also recorded so that if you can't make it at the time it is, you get access to the once you register, you get access to the recording afterwards. I'm done with the first lecture putting together, and I'm looking at voting trends in the state, looking at where Biden and Harris made inroads. Looking at how different this was since the last time the Democrats won in 1992. looking at trends over time. And the second lecture is going to be all about the Senate elections and looking at where Ossoff and Warnock need to do well, similarly to Biden-Harris, but there's also places they need to do well that are different than Biden-Harris. And so this is not a rerun of the presidential election. This is an election that starts with that as a foundation, but is going to have its unique characteristics. And the Dems do not have a good track record of winning runoff elections in Georgia, but this is a brand new day. And I believe in Stacey.
So David, we have a couple of questions. What can we do now to build support for the 2021 Voting Rights Act? And as a sort of tag onto that question, are we going to be focusing on Secretary of State races, seeing that the Secretaries of State are so important in this effort?
Yeah, on the first question, winning Georgia is really, really important. But it is a reality that even if we don't win Georgia, the Senate is 52-48. And there are some possibilities out there to get certain things through. They would take trade-offs, but could get certain things through. So the most important thing we could do to build support for the John Lewis Voting Rights Act would be to win in Georgia. That would be the most important thing we could do. If we can win in Georgia, then we will pass that legislation. I am certain of it. After that, though, the most important thing we can do is support organizations that are doing the necessary long-term arc of this work. Common Power is one, but there are some incredible ones around this country. New Virginia Majority has been doing incredible work, and they've helped to turn Virginia blue. What a transformation we've seen in that state, okay? Advanced Carolina is an organization. We work with all of these. Advanced Carolina in North Carolina. In Arizona, Mi Familia and Mi Familia Vota are incredible organizations that are doing this work. So I would say supporting those organizations that are doing the long-term arc of voting justice work. The main problem that communities of color say to predominantly white organizations and political party leadership is you only show up and you only invest in us when there's an election. Where have you been? And so the trust isn't there. The infrastructure isn't there. So we have, from the beginning of Common Power, taken a long vision of this. And I really encourage you to see Stacey Abrams's documentary that just came out, All In, The Fight for Democracy. All right, it's on Amazon, and it's about the work that she's done since 2010 in Georgia. Georgia and Virginia are models for the rest of the country, investing in these kind of key on-the-ground organizations that are doing the work to transform within. Now, for Secretaries of State, there's no question that Secretaries of State and Attorneys General really, really matter. This is probably nothing that you all know this, but that they really matter. When you look at the 6 key states in this presidential election, across the top, the Wisconsin, Michigan, Pennsylvania, and then across the South, Florida, North Carolina, and Arizona. And then you can add Georgia in there. The reality is that when you started with those first 6, 5 of them had Democratic Secretaries of State. And so there is hope in those places that ballots will be counted fairly. They will protect absentee votes, for example. The Democratic Secretaries of State in Wisconsin, Pennsylvania, and Michigan, I mean, it's just monumentally important. You remember the Secretary of State in Florida and how she helped to shut down the votes in 2000. How important that was. So it really, really matters in those states. Now, most of those Secretaries of State will be up for re-election again in 2022. So we will be investing in Secretary of States, in Attorneys General, in governorships, in Senate races in those states. That really, really matters. And then we have a Secretary of State in Georgia right now who's standing strong, and that's, we didn't expect that. And you know, we work and support Democrats at this time, but we are eager to support Republicans. And Ravensburger is a dyed-in-the-wool Republican. He is. And also, the only way we're going to come back from this as a country is to get dyed-in-the-wool Republicans who really believe with all the integrity in the world that this is more important than party. Right? So we'll be prepared to maybe support him. We might end up supporting Stacey Abrams, the Raphael Warnock, if he wins this when he wins this election in we might end up supporting him because he has to run again in 2022. So Abrams for the governorship, Warnock for the Senate, Secretary of State, but we might end up supporting Raffensperger for the Secretary of State if he stays strong like this.
So David, we've had a conversation earlier, okay, about the Electoral College and the popular vote. And I'd like to get your thoughts on the prospects of Electoral College reform, whether you think that's in the cards or no, and the two sides of the coin, if you can.
Sure. So the electoral, I have done in my voting rights talks, I do a good chunk of a lecture on the Electoral College. The Electoral College goes all the way back to the Constitution, and then the idea of it, and then the implementation of it is rooted in enslavement. It's rooted in enslavement and the allocation of representatives and senators in this country. So it, like a lot of things in this country, it's rooted in that racism that of slavery. That alone should lead us to have a serious conversation about it if you're really committed to voting justice. That alone should lead us to that conversation. Further, we know that the reality of population distribution in America today means that the Electoral College has a Republican bias to it, where they can win enough states with far fewer votes. That's what I mean by a Republican bias. They can win enough states to win the Electoral College, but to lose the popular vote. And that bias, which got Trump elected in 2016, got George W. Bush elected in 2000, was about 3 percentage points. Like, you could have a popular vote that could be won by a Democrat by 3 points, but yet the Republican could win the Electoral College prior to this election. You now look at it in this election, and it's more like 5.5 points in this election. Donald Trump is going to come within about 60,000 votes of winning this election in the Electoral College. When you take the 10,000 votes that are there in Arizona that Biden's going to win by, the 12,000 votes in Georgia that Biden's going to win by, and the 20,000 votes that are present in Wisconsin that Biden's going to win by, you're getting really close. And then about 10 to 15,000 in the Nebraska 2nd congressional district, where there's one vote, one Electoral College vote. You're getting really close to Donald Trump actually winning this election in the Electoral College. Really, really close. So I really favor us moving to either entirely by popular vote or some kind of system that takes into account the popular vote and the Electoral College. The argument for the Electoral College is that it gives every state some impact on this, no matter how small it is. They get at least 3 votes. A Wyoming and Alaska, Montana gets both the Dakotas get 3 Electoral College votes. The argument against it is, of course, that the distribution of those Electoral College votes do not follow closely enough the population in this country, and so the population, we're not living up to the Supreme Court mandate of one person, one vote. All right, we're not living up to that, and a really great book that I recommend to you all, I was just looking on my bookshelf to see it was over there, but I have it electronically. It's Dr. Carol Anderson's book, One Person, No Vote, which takes the Supreme Court decision and language of the 1960s of one person, one vote, and updates it today. That we have too many situations in America where a person doesn't have a legitimate vote. It's suppressed, or it's just outright not honored. So I would like to move to a system where either it was the entirely popular vote, or there was some kind of system that took into account popular vote plus Electoral College. None of that's going to happen, though, without one of 2 things happening. So none of that's going to happen without one of 2 things. Either A, we amend the Constitution, and it was back in the 1960s where an amendment to amend the Electoral College came within, I believe, 1 vote of failing to pass the Congress. All right. At that time, it was Republicans that wanted to amend the Constitution. It came very close, but didn't pass. Today, it's Democrats, of course, who want to amend it. So we either got to amend the Constitution, always a heavy lift, or 2, you have to have enough states come together and build a compact, an agreement that they will direct their state electoral votes to the winner of the popular vote. and there is this movement. It's called the National Popular Interstate Vote Compact, which is states making agreements where they say, we will maintain our electoral votes, but we will give them to the winner of the popular vote if we get enough states to sign on to this compact that we get over 270 electoral votes. So it does not kick in until you get enough states that cross the threshold to 270. Every state that's passed this, and we're up to about, I think, 195 electoral votes now when you look at the states that have passed this. Every state has passed this as a law, and then it's either been also affirmed by a statewide popular vote. In Colorado this time, the Republicans didn't want the state legislature's passing of it, the Democratic legislature, to stand, so they pulled a legislative maneuver and got it on the statewide ballot, and it passed in the state ballot. So Colorado is part of this. None of the laws the law is not in effect for any state until you get over 270, enough states over 270. There are enough blue states in this country now that could pass this between now and 2024, that have the mechanisms to make them happen, either statewide ballot initiatives, or they have control of the state legislature, that we could get this passed by 2024. It sounds radical. I know it's a little nerve-wracking to think about this, but the reality is that the Electoral College has a built-in bias. The US Senate has a rural pro-Republican bias, and so does the House of Representatives, has a gerrymandered Republican bias. So unless we start doing some things, and there's nothing illegal about this, and it's not as radical as adding justices to the Supreme Court, I'm actually kind of hopeful about this. I'm kind of hopeful about this. I'd at least like us to take a run at it, Ron. I'd like us to take a run at it.
It's called action, David. Thank you very much, David, for your incredible presentation this evening. If we can give David another virtual round of applause. We really appreciate you being here. You taught me a lot, and I hope you inspired the folks that are here, from various advisory groups and from various endowment grantees, to take the information about David's organization back to your constituents in those groups. That's how we grow our action. That's how we grow our momentum. Get other folks to do it. Get other folks to look at your site. Get other folks to click that button. Get other folks to do some calling, to do some postcarding, like I'm doing. Okay.
Hey, Ron, I do want to, I have to, as like one of the leaders of our organization, just say we're an organization that is a hybrid. We're a PAC and a 501c3. And our 501c3 work is dedicated to our education and we have a little college age internship called Action Academy that had 62 people from around the country in it this summer. So we can receive support or either way. And so we've been fortunate to receive some C3 grants to support this work. So as you all are thinking about ways to engage, just know that we are flexible. We are flexible on our side of this, and we are entirely privately supported. And our leadership team is 10 full-time folks, and 8 of them are people of color, 6 of them are women. I'm an outlier. I'm the oldest. I'm 53. The next oldest is 37. All right. So we aren't just doing the work, we're building the next generation of leadership. So it's an honor for me to come and talk to you tonight. And you all are leaders. I know you are. So I appreciate the chance to come tonight.
Thank you so very much, David. And for the rest of you, thank you for joining us this evening. I hope to see you all in January when we will have our next in the series on housing and justice. Until then, have a wonderful holiday. Have a safe holiday. And we'll see you next year. Thank you all.
Great job, Ron. Great job. Excellent, excellent moderating. That was fun. I learned a lot.
So did I. So did I. It was a lot of fun, actually.